May I please, Your Lordship?
One second.
May,
Just 1 second.
Start these proceedings. But I am appearing on behalf of the major Milord Industry Association, which is the ASSOCHEM, UK Milord, and CI. So we have filed applications today morning. Lord,
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rodhi, sorry, no oral mentioning in my court.
No, I'm not Milord. I'm in the matter. I'm saying. I am saying.
We have no such application on board. Let it be circulated. We'll deal with it in the normal course.
But Milord, I am respectfully submitting. If
Sorry,
Your Lordship make
appearing
an order
for big
today,
clients, we will not tolerate this. You have to follow the rules in my
but
court.
Milord, if Your Lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alpha numerical.
Mr. Rodgi, you are aware about these proceedings going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
No, Milord, the order is of 15th March. Ask
No, but
Milord,
you are aware about the proceedings pending before this
but
court.
Milord, we were
Arguments
not
are going
parties
on
anywhere.
together.
We were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Milord, I have
Come
no.
back 1 second, Mr. Rodgi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Milord, I have come only in regard to
Circulate and-
15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodgi,
declaration
I hear you.
of the list of donors
Rodgi.
or the list of recipients.
Mr. Rodgi will not hear you right now. We have a specific application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a, we'll get it. No.
I am saying
No,
kindly, Milord,
If I do it for Mr. Rohatgi, senior
No, no,
counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the
I am
gander.
not mentioning, I am not appearing in the matter and
No,
making
we
a
have-
submission.
We have no such application on board before us.
Milord, I have got it with me.
I've made myself
my Lord, the
clear.
entire,
I have emailed
entire
you.
judgment
1
has.
second, you wait. One at a time. Sorry, Mr. Rodgi. Yes.
No, my Lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute residicata. This judgment doesn't constitute residicata.
Mr. 1 second.
Yes.
1 second.
This
1
judgment is
second.
void.
Please listen to me. You are
It is-
not, 1 second.
I am a citizen of this
1
country.
second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my Lord.
File an application. What I told Mr. Rodgi applies to you.
No, my Lord, the question is, my Lord, this.
There's no question you've got.
My friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No
my Lord,
further.
we will go by what your lordship.
all, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my Lord, your lordship will go by
You have
whatever
had
your
enough
lordship
committed
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't
Please.
constitute. It is not a
Please
representative
do not,
process at all.
please, once we have said no, please move the application by
Exactly
email.
what your lordship says.
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
Nedumbara, you are
All the way come from Kerala.
you are obstructing in the administration of justice.
Pardon, my Lord?
You are obstructing in the process of administration of justice.
The entire judgment is against, behind the back of these people. Parliament has been rendered
Please,
irrelevant.
that's all, that's all. We heard that, please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
No, no, we are filing it.
Please do,
We are filing it.
please do, we'll consider it afterwards.
That's
That's
it.
it.
10 o'clock.
I-
My friend came from Kerala to took a 1 o'clock flight.
Have not-
Be kind to us. Be
last-
kind to
That's
us.
all, please, we will not hear that.
In democracy.
Please call for the
the-
application,
the
please
rule
follow
of,
the application.
democracy seeks
My lord,
to-
may I mention, my lord, my petition for so moto that is pending, whatever lordship want to do, that do only, I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you're the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, yes, my
You
lord.
have no locus to mention
So
anything.
that I should not
You
disturb
have to
lordship.
restrict what you
We
have
should not
said.
waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
But
only that.
These are all publicity oriented stunts. We will not permit it.
Not a handmaid of a.
Whatever
Please,
lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
My Lord,
Please,
we are all
please close it.
members of the bar who are senior to your lordship.
Nedumbara, it is enough now.
Also senior to your
It
lordship.
is enough.
65-year-old man, Lord.
Be kind to us, sir. We are very polite and begging with your lordship. Your lordship has a soft language.
Madhupara, we have been telling you that you are interfering, you're obstructing us.
No, no, no.
But
How can it be said?
now, if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, my lord.
Follow the line.
Yes, Bala. Yes, hearing now. We issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing for
I
the State Bank
appear.
of India?
Mr. Salve is also there.
For the State Bank?
That's right.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So,
But I,
let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
Malad, I just, whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem.
Tell us
Somebody
one-
can screen them.
Why has the SBI not disclosed?
I wanted to, Malad, tell Malad how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. Well, of course, if your lordship say give anything more, everything will be given, but there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
Malad, how we understood,
The
may
SBI
I-
requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
May I, Malad, take your lordship through the 3 orders to how we understood them? Malad, your lordship's first order was 12th April 2019.
Yeah.
And we have, for convenience, Malad, we have put the 3 orders together. If your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, Malad, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not
Yes, para 17, right?
para 16, Malad.
16, you got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After Malad noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
All right. Can we just see para 15 again, Ron?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives
But
the requisite
Salve, we
details.
take it you're not arguing a case for a political party, right?
No. On the contrary,
Appearing for the state.
I'm saying the reverse. I'm so sorry. I'm saying the reverse. But if a political,
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the
correct,
to the election commission.
correct, and they have, and this has.
No, that's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were
Yes.
also supposed to.
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with, as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not preparing for a political party. Then, my lord, Para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The sealed covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as a alternative to this system. And in the conclusions, which are para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donation received from donation must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says, I have received so much money from so-and-so. Then it says, during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarify para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and sealed cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the sealed covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains a direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, my lord. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, my lord, as we therefore understood this, the political parties have come and said, we have received so much from so and so. The details which we will give will make the database complete so that we have who purchased, when he purchased, and when they have got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First,
Yes.
tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, my lord, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you
In
store
two
it?
silos. Your lordship noticed that in the next order. So the data is maintained in two
Actually, you store
silos.
it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first
No.
silo is the bond number. The
Bond
second
number is
silo
only on the bond.
purchase, and the third is the redemption.
My lord, bond number is only on the bond, and it is cannot be read except through under a UV light. That was only done, my lord, like authentication, like because it was a bearer bond. That's what was sought to be
The
issued.
purpose of the alpha, and second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
The
it
security feature entirely.
in the audit trail? Do you also
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question,
Yes.
how does the redeeming branch
Yes. Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it,
Yeah.
the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's a currency note.
alphanumeric.
Yeah. But
Cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think
was it
Mr. Bhushan
purchased in
should
the
hold
last
his
15
peace for a
days?
minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a
All
number.
the details of the purchaser and the bank which issued the bond when you scan the bond?
No, that's what I'm saying. That correlation was not kept for the reason it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Orchard. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
My lord, even in the final
You can't
judgment.
say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
My lord, your lordships.
All details.
That's why we came to my lord.
Mr. Salve, we'll clarify to put it beyond any.
No problem. No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains. But
Details, you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners who say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, Malad, the media constant beating down and the petitioners giving public interviews saying we will take the state bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your lordships granted an interim order saying keep records. It wasn't at that time, my lord, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships were at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, matters your lordships will.
Mr. Salvi, the idea behind the interim order was, in case a writ petition is allowed, then
Yes.
data should come out. And that's what exactly is required, nothing more.
I must say so, my lord, as out of whatever, as my lord, the Chief Justice is saying, your lordship will clarify, we will give every bit of information, relevant, not relevant, we'll give every bit of information which we have. So that, my lord, there should be no feeling that SBI is interested in somehow holding something back. I only want, my lord, to share one thing. My lord, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing that Lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your lordship's judgment. That was not what it was meant for. And your lordship will see whatever safeguards need to be put in place.
Just one more
Lord,
thing.
I have 2 minutes, my lord, if your lordship permits. At the outset, my lord, on behalf of the central government, I completely disassociate myself with what Dr. Agrawala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my lord, on behalf of the central government. Now, my lord, I have something to share, and I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. Your lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened is, my lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. Lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord, and your lordships also, my lord. That's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, my lord, a non-level playing field, my lord. On this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a series, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. My lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of my lord, posts are being made. I know, my lord, your lordships cannot control them. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control. Lord, that saying Mr. Rohgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
As judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm
We
not,
are-
my lord,
we are-
for a
Our
second saying.
court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
All right. Order.
One fact.
Can I assist you? Lord?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
One fact, one fact.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we'll not hear you when your application, we have to follow procedure in the court. It's a constitutional court.
One will allow
Yes,
us.
Mr. Rodgi,
Say
no,
something.
Mr. Rodgi. I told you the reason for it. We are now at a stage when the
I am
judgment
not
is
on my
declared.
application, not that it has become infirmable.
Sir,
I am
Mr.
now
Rodgi.
only saying
No,
that
Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party
I
assistance.
meant not.
Your lordship didn't get a
One
proper
second, please.
assistance.
So just one
The
thing.
grievance of those who will now be deemed that you have given to A party, you have given to B party, that will
That
be.
was precisely the answer. That was.
Lord, one more clarification.
What we did that we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition.
No problem in.
Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court.
Absolutely.
And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization of B?
Answer is yes. Answer is.
The answer is yes, not that I can't.
Lord, only one line, my lord,
Yes,
only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your.
He has done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my lord. That my disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of
Yes, my lord. Yeah, but maybe treated as my lord.
We must tell you that we respect this very responsible approach which the Solicitor General has adopted of, because, clients apart, who you are representing apart. The
It is
institution has
really
to stand
painful,
above
my lord, when the people before the court start, my lord,
Thank
a
you- thank
media
you for-
campaign
thank you for
to
saying that.
embarrass the judges.
Thank you for
It-
saying that you
it's
don't
very, my lord,
associate
painful.
with the mentioning. Thank you for saying that you don't associate.
Because
with the
there is no level playing field. I can't hold a press conference.
So, Solicitor, unfortunately.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are.
Last order, the election commission has put out the sealed covers but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into
No,
all
but
that,
because-
Mr. That's
because-
not our remit at all.
No, I
Yes, what has happened after the judgment is not something we are concerned
Not
with
after
at
the
all.
judgment. What I'm saying,
Now-
no, what I'm saying is this, that since the order of the,
Very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It's the property of the nation. And
no, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not
the names of
addressing
the
your
donor.
lordships, he is addressing somewhere else.
The-
Kindly hear him
the-
for some time.
correct.
So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan
amazing.
vehemently said this. That's
Amazing.
the purpose.
I'm
Solicitor,
pointing out
unfortunately,
something.
public interest litigations have now become publicity interest litigation.
It is
Absolutely.
publicity interest litigation.
I
It
am
is, my lord,
pointing
there
out
are some hidden agendas. There
something.
is no doubt, my lord, and I am not, my lord, apologetic in saying.
I'm astonished.
And
Lord,
that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately.
Lordships, in your lordship's majesty,
So what
would
I
not
was
know, my
pointing-
lord, what are the hidden agendas
Let me
behind it.
just dictate a short order. I
I
think,
just
we
point
are
out that
unnecessarily expanding upon the remit.
because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the order.
Therefore, what all that I'm requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order.
They have filed an
Just, Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Why should we, in our interim order, we said that the disclosure shall be made with effect from the date of the interim order.
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the
So
judgment.
the only reason why I'm saying
can't
that,
modify that date.
no, the only reason, because your lordship asked the political parties to give donor details to the Election Commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore, I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems, a lot of your issues will get
But for
solved.
that period of 2018 till
Oh, that's
April
we are not sitting in a
2019,
review.
We have taken a conscious decision.
we are
Please
faced
file
with a
review.
situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
no,
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
it was not a
If
clash
the
of
political
interests,
parties
it was
had
conscious.
disclosed the donor details, this would not be required.
Draw the line somewhere, we had to hold the balance. We've held the balance ultimately.
As your
at
lordship
2/12.
pleases, but I just.
Can I just add one sentence? Lordship said all the details, Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number, because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying just. When a lordship said all details, my lord, in my respectful submission, it will be.
Mr. Sarve has been.
No, my lord, lordship, just permit me a minute.
Sarve has fairly stated that he will,
No, Lord.
all the details.
No, Lord.
Why?
Yes, yes, ma'am.
No, my lord, if I can just show.
And date are all already
Consider what your
disclosed.
lordship would say, my lord. I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. My lord, this will cover all the details, my lord, in my respectful submission.
My lord, this is now asking us to sit down and collate one
This
with
is a
the other.
commission made to the court. Just like Mr. Salve made a submission to the court, I'm making,
Yeah, we need,
very well, I'm making a submission to the court, Mr. Salve asking us to do whatever. Look,
Please permit the, my lord, the
Well,
chief justice to
uh,
dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord, I filed that IA. For a preview, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only, because we said, my lord, it should be, my lord, otherwise logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, then,
that's
very well, I'll leave it at that.
and there is a specific direction with effect from 12th April.
Then your lordship said, I have not pressed the
So
application.
Bhujan, there will be no end to it.
What is the IA number, Mr. Ansari? Just 1 second, Mr. Bhujan. IA number which you are not pressing is IA number?
Diary number 12580-2024, which is MA number, MA diary number.
So that you are not pressing.
Yes, my lord.
Just
Just
one,
say it, MA
by way
diary
of
number
information on
12580-2024. Mr. Vijay Hansaria, Learned Senior Counsel, appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of,
one
my lord,
thing.
whatever proceedings have gone to the court, in view of the proceedings before,
Whatever in view of whatever.
Lord, if your lordship can say that, my lord.
Oh,
Otherwise,
what? In view of what? In view, we'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
just one fact by way of information.
Enough of assistance by this public spirited person, my lord.
The details-
Your lordship doesn't need any further assistance.
The details of the number of bonds shown by the, in the data. which
He is
has been
gathering the
submitted,
details for a future PIL, my lord,
The
so that
number of bonds-
remains in,
the
he remains
number of-
relevant.
Now, please permit the, my lord, the chief justice to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores, and the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now, the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, my lord, these figures are not authentic. I've given the authentic
18,000
figures.
versus
Roughly
22,000.
Sponsored NGOs are, my lord, fudging the figures and bringing their own, my lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein, that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that
And
18,000.
this is what happens
All right,
when
we'll now
it,
leave it at that. I will.
My lord, those numbers are not right, since, my lord, because all this is going to play out, the numbers are not right. The corrected numbers were, my lord, given in our application.
वो अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. In subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, comma, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T 2, political parties which have received contributions through electoral bonds is specifically since the date of the interim order dated 12 April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance?
What is it that you want
Yes.
clarification? Mr.
Maharaj, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Maharaj, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Maharaj. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
Will not go into all that. I mean,
No, I have to convince my lord I have complied with the order. I'm just saying.
File a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, this court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. These directions in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019 till date to ECI. Full stop. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and the plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression, to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Full stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of, and the serial number, if any, of the bonds which were purchased and redeemed. Full stop.
Is that voting number one would be?
The application, this was on your application, I think you had moved this, no? The application was by Oh, yeah, we had, therefore, Mr. Mr. Harishan Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
But we have one more day on Thursday.
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
This will be given to the election commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the election commission.
The election commission shall upload the details forthwith on the communication by SBI.
My lord, I had directed my lord, the senior official of the bank to remain present. My lord, the deputy managing director and chief general manager are present here. The presence may be required. They both are.
Fair.
Mangalam Cement, 45